very interesting High Court case after being launched there by a married couple whose loan was taken over, home loan was taken over by Pepper Finance. The couple are basically challenging the interest rate being charged by Pepper, which they claim is an unfair 8.5% mortgage interest rate. They're basically arguing that they are entitled to Pepper charging them the rate that the permanent TSB would be charging them. So they're a married couple, they brought High Court proceedings. They're claiming the financial fund, that is Pepper, that acquired their mortgage from a bank is now charging them an unfair 8.5% interest rate. This case, this decision, will have major implications for thousands of other mortgage holders. They have sued Pepper Finance Corporation Ireland, which acquired their mortgage, which they took originally out from the permanent TSB for a home in County Cork. They claim that Pepper, which is described in legal papers as a vulture fund, is charging them an unfair 8.5% interest rate when they would be paying just over 4.3% if their loans had remained with PTSB. So their loan was transferred from PTSB, permanent TSB, to Pepper, and if they were still with PTSB, they'd be paying 4.3%. Instead, they're paying 8.5%, practically double. They claim that Pepper, as successor in title, remains bound to the same corresponding rates of interest as those currently offered by permanent TSB. This is an interesting argument. The couple took out a 35-year mortgage with PTSB in 2005, and then there was further borrowings in 2007 to renovate the property. The loans then were sold by PTSB in 2019, had fixed interest rates for periods before a variable rate kicked in. It's claimed that Pepper justified this variable rate on market conditions, including recent increases by the European Central Bank to address high inflation. In their action, the couple who dispute Pepper's justification claims the rate they're being charged is excessive and out of proportion with any legitimate rate they should be charged. They claim that Pepper must abide by the terms of the loan agreements they entered into with the permanent TSB. The rate they allege is being driven exclusively by Pepper's desire to obtain the maximum amount it can extract from its consumer base with a view to making a profit. They're looking for a declaration that the mortgage interest rate they're currently being charged is out of all proportion to any legitimate rate allowed under the loan contract, and that Pepper has been unjustly enriched at the couple's expense. They're also seeking orders obliging Pepper to charge them the corresponding interest rate that PTSB would be charging them. They also want a court to declare that Pepper charging them an interest rate on the mortgage that is higher than the corresponding rate being charged by PTSB is unlawful and in breach of European Union regulations on consumer contracts. These proceedings may have a bearing on hundreds if not thousands of other mortgages, and the couple has kept up with their scheduled mortgage repayments, but they're finding it increasingly difficult given the increase in interest rates. And there is one other important or unusual feature of this, that counsel acting on their behalf said their actions based on decisions made by the Irish and UK Supreme Courts, and they claimed that by exercising their discretion to increase the interest rates, Pepper has failed in its duty known as the Braganza duty to the couple. So the Braganza couple or Braganza duty, and I've never heard of it before, quite frankly, gets its name from the English case law, is where contractual discretion must be exercised reasonably and in good faith, and not arbitrarily or capriciously. So the action came before the High Court on Tuesday. The couple are on an ex parte basis asking the court for permission to serve short notice of a motion, in other words an application, where the plaintiffs seek to have a timetable put in place for the exchange of legal documents in the dispute. The judge adjourned the case to a date later this month. The outcome of that will be interesting, to put it mildly, I haven't seen a case like that before where the argument is that the lender is essentially charging what's called, or what's described as, an unfair mortgage rate. But the interesting argument is, obviously, they're making is that if they took out the loan or permanent TSB, then they should be entitled to whatever permanent TSB are currently charging. I'm not sure that argument will succeed or not, but it will be interesting to see what happens. Hope you find this useful. If you do, would appreciate if you gave it the thumbs up down below. If you're watching on YouTube, you may be interested in subscribing to my channel, and if you're listening on Spotify or iTunes or wherever you listen to podcasts, I'd appreciate if you left a review. Thanks a lot.